that I would say, I recollect differently. But I would no more put any of my friends in the jurisdiction of his authority and this court's authority and subpoenas and bonds and everything else to testify against you.
Because
I don't care, Your Honor. I'm here to protect Seth and anybody else.
Can you redirect?
Yes.
Under the case of People State of Michigan versus Flores, file 23-868SD. So, Ms. Bridgman, if you want to come forward to the table.
I'm unable to do that. I don't have a license to practice law in the bar arena and in the water. I am a woman on the land, under the law of the land, and under the one true God. I'm a living soul. And
Okay,
you're offered a contract with Beth Michelle Bridgman in all caps. I'm not that person. Anybody else in this room that person?
Hey, hang on.
Okay.
So, Ms. Bridgman, you're correct that the bar in the courtroom, people have to be licensed attorneys to cross the bar to represent other people. Of course, people can and do, as you have, represented yourself on this side of the bar. So you're welcome to sit at the table there, which would perhaps be more comfortable for you. If you would prefer to proceed from where you're standing or sitting, that's fine with me as well. Do you have a preference then?
I'd like to stay right here.
Okay, that's
my
very
honor. I think the first matter I need to address is that I have a copy of your sworn oath here, and
that's not relevant for today. So, Ms. Bridgman, you filed a motion for me to recuse myself. I'm going to deny that motion. It didn't present any basis for recusal, so that motion is denied. And we're here for a contempt hearing, which you've been arraigned on for your contempt for interfering with court process and unauthorized practice of law, and then failing to attend the hearing.
This is true.
So, Ms. Miller, any opening statements?
Yes, Your Honor. I will show through the evidence that Ms. Bridgman engaged in the unauthorized practice of law that is contrary to MCL 600.916. She further prevents.
The tension inside this Michigan courtroom is already reaching a boiling point, and we're barely minutes into the hearing. What began as a routine contempt proceeding is rapidly spiraling into something far more dramatic. Bate Bridgman is not just challenging the allegations against her, she's openly challenging the legitimacy of the court itself, the judge's authority, and even the legal system operating around her. Every response she gives pushes the atmosphere further into confrontation. The judge, meanwhile, is attempting to maintain order while carefully navigating statements that are becoming increasingly disruptive. You can already sense that this hearing is no longer simply about an alleged unauthorized practice of law case. It has become a direct collision between courtroom procedure and a defendant who refuses to recognize the court's jurisdiction. And as both sides dig in deeper, the possibility of this situation escalating into outright chaos becomes impossible to ignore.
And the defendant in the underlying case from meeting with his MIDC attorney prior to his arraignment on November 30th, 2023, and she also failed to appear for her show cause on December 20th, 2023, 11 a.m.
Do you wish any witnesses sequestered?
I don't believe so.
Okay, Ms. Bridgman, now's the time you can make your opening statement to me, but first, do you wish to have any witnesses that will be presented sequestered, meaning that they have to leave the courtroom and be instructed to not watch the
I'm not even contracted with this hearing, this administrative hearing. I cannot be adulterous to my own oath of office.
I'm going to assume that you're rejecting my
under an
request for
authority.
sequestration orders, and no sequestration orders. So go ahead with your opening statement.
Law is must be a contract. In the absence of a valid contract, there is no law, period, which might be part of the problem that we have here. Now,
I don't mean to interrupt you, and I'm not going to interrupt you often during your opening statement. I do want you to know that because of the way the video feed works, from where you're standing, it's not picking you up. And I assume that the audio is going to work through for the district courtroom that's clerking it. But
I'm content with all the people that are here that reside on the land that most of us call Michigan. If that's who is bringing charges against me and there is no person injured, there's no property damage, there should be no case. So my statement is that how can I put myself in your jurisdiction, except that you could do it by force and arrest me with 4 deputies with no due process and violate my unalienable rights to try to force me into your jurisdiction? Because your oath of office is a violation of Section 5 United States Code 3001. You do not have an oath giver. You have yourself that signed it, and you have a notary. I just did an oath with the people here today, and they signed it, I signed it, and we got a couple of them notarized. That's how it should be. This is not a valid oath. I cannot stand in this court and be brought up because, in fact, you are operating or masquerading as a lawful court, but you're in fraud of the very oath that would give your court legitimacy. I have a remedy, Your Honor. I have an oath here, and if you would like to take it in the presence of the people and sign and notarized, we can move forward. Otherwise, I would be violating my very own oath of office, and an oath I just took downstairs as well, to the United States of America's Constitution.
All right, does that conclude your opening remarks?
Well, it concludes the fact that I see that you're not interested or care what the people and the truth of the lawful process of the people. I don't know if anybody else cares to say that. There's no injury and there's no property damage. I do believe I withheld Mr. Gilbert from some money he was probably banking on that day. And I believe the court operates in commerce and is here to make a profit on all of their activities. So that is my violation. The state of Michigan hated that I blocked an attorney before Seth was arraigned. You cannot be bringing me in the hallway downstairs and charging me, and then tell me that you're the true judge of the 53rd Circuit Court when your oath is not properly even administered. I happen to know, I believe, did you take a Bar Association oath?
I'm not answering questions. Are you done with your opening statement?
I guess I don't really need to be here because this is not a legitimate court that I should be standing in, and I will not violate my own oath by submitting myself to an authority that has not done the proper oath himself.
All right, Ms. Miller, your first witness.
Thank you, Your Honor. The board
Ms.
call.
Bridgman, you may not leave the courtroom.
I know you have people that need to know that they are violating people's unalienable rights by picking them off the street without a single piece of paperwork.
Okay, Ms. Miller.
At this moment, the courtroom dynamic changes dramatically. Bridgman has now escalated from questioning procedure to directly accusing the court of operating fraudulently. Her repeated references to constitutional authority, oaths of office, and so-called illegitimate jurisdiction are creating an atmosphere that grows more volatile with every passing second. The judge's responses remain measured, but the frustration underneath is becoming increasingly visible. This is the exact kind of exchange that courtroom observers often describe as a dangerous turning point, where legal arguments stop being procedural disagreements and become personal challenges to the authority of the bench itself. What makes this even more intense is that every statement is happening on the official record, in front of witnesses, officers, and court staff. One wrong interruption, one emotional outburst, or one refusal to comply could instantly transform this hearing into an even more serious contempt situation.
Who's your first witness?
We would call
Does
the
anybody else have a problem with this?
All right, hang on. There's going to be no outbursts in the courtroom, or you'll have to be removed. All right, Mr. Bird, please raise your right hand. You may not leave the courtroom. You swear to tell the truth, the whole truth, and nothing but the truth, so bad?
Yes.
I'd be happy to administer a
Ms.
legitimate oath.
Bridgman, hang on. So the court process works. I gave you both a chance for your opening statements.
This
Hold
is
on,
not a
hold on,
court
hold on.
I can submit to.
Hold on. The process is going to be,
I know you
Prosecutor
like to look really regal up there and
You know,
maintain a degree of authority, and
Ms.
you have
Bridgman.
guys carrying guns.
Ms. Bridgman,
I'm fully aware of that. Where are their
I
body
can-
cams and their vehicle
I can
cams?
put you in the jail cell, you can watch it from there.
I know that's what you're hoping to do.
So Ms. Miller's gonna be given an opportunity to question the witness, and then you'll be given an opportunity to question the witnesses. That's how court procedure operates. If you interfere with that procedure, you're gonna be in direct contempt of court. Ms. Miller, proceed with your question.
I would have to be.
Please state your name for the record,
David Berg.
and can you spell your last name?
BERG.
And how are you employed?
I'm the IT director for Sheboygan County.
And in that capacity, are you able to see and access the surveillance footage in the building?
Yes, I am.
And are you able to pull portions of that video off the server?
I am.
And were you working that capacity on November 30th, 2023?
Yes.
And are you aware of security footage that was pulled from the system for that date?
Yes, I am.
Do you know what the time frame of that security footage that was pulled was?
8 to 10.
And do you know what part of the building was pulled from the system for that time frame?
There were about 5 camera views, mainly downstairs in front of district court in the entryway.
Okay. And did you review this thumb drive prior to sitting here to testify today?
Yes, I did.
And does everything on this thumb drive, was that pulled from the system from November 30th?
Objection, this is all hearsay. Anything that is on that video is all hearsay.
It hasn't been offered into evidence yet, so hold on a second.
So you were able to view everything on the thumb drive?
Yes.
And was that all footage from those cameras from November 30th?
Hearsay.
Yes.
It hasn't been offered into evidence yet. Hold on a second.
And
No, I know your presumptions are that if it's said in court and it's not objected, it becomes presumptive evidence.
All he said is that he reviewed it, so continue.
And did it appear to be
She is leading the
edited in
witness.
any way?
I'm sorry, what's that?
Did it appear to be edited in any way?
No, software that we have to allow us to edit.
So it's the full capture of that
Yes.
time frame.
Yes.
Okay, I'd move to admit People's Exhibit 1.
Okay, Exhibit 1 has been offered for admission. Ms. Bridgman, do you have an objection?
I have an objection that anything in the hallway is going to be considered contempt of court.
Okay, it is, I'm gonna presume that that's an objection as to relevance. It is relevant, objection over Exhibit 1 is admitted.
Thank you.
So, my honor, can we move to settle this? Because I know your main objective is to get me into jail unconstitutionally again.
Ms. Bridgman, I assure you that is not my objective today. If it is your objective, there's easy ways that you can make that happen by continuing to behave the way that you are. But I assure you that is not my intention today. All right, so one's in.
Thank you, Your Honor. The time frame on the video is 2 hours. I don't think the court wants to, I don't want to show the full 2-hour video. If I would be allowed to present various snippets of relevant time from the video.
Okay, go ahead. All right, so Ms. Bridgman, Ms. Miller's gonna play portions of the security footage for the court. I'm not sure if you're able to see it from where you are standing. Again, I invite you, you're welcome to sit at the table where you can see the footage.
And
I
for the
was
record-
there, Your Honor, and before the living God, I know what's on that video, and I have not violated or broken any laws. I have stood in the way of your Commerce Court, so I understand that that's a contempt of court charge because you're a for-profit court.
Okay, go ahead.
And for the record, my office did contact Ms. Bridgman to offer to give her a copy of the flash drive or have put on a flash drive for her, and she indicated that she did not want a copy.
Okay, go ahead and play.
Well, then I can just reserve to show the clips in
Okay.
case we need to later on. Then I have no further questions for Mr. Burke.
All right, Ms. Bridgman, do you have any questions for the witness, Steve Berg?
When's the last time you were at Salvation Army with your daughter?
Couple weeks ago.
Sorry, I missed it. That's all I got.
Okay, thank you. Your next witness?
Thank you, other people would call Seth Flores.
Now, Your Honor, before you call the next witness, I would love to be in honor in your courtroom. And I would ask that we would settle to save this young man.
We're in the middle of it here.
Now the courtroom enters its most critical phase so far, witness testimony, and you can immediately feel how fragile the situation has become. The judge issues a direct warning that any further interference could result in contempt, and the tension in the room becomes almost unbearable. Bridgman continues interrupting proceedings, insisting that the court lacks legitimate authority, while the prosecution begins laying the foundation of its case through surveillance evidence and witness testimony. What makes this exchange so dramatic is the complete contrast between the two sides. The court is attempting to follow strict procedural structure, witnesses, exhibits, objections, testimony, while Bridgman repeatedly challenges the very legitimacy of the process itself. It creates an almost surreal courtroom environment where every answer, every objection, and every interruption feels like it could trigger an explosive reaction at any second.
Please raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Okay.
Can you state your name for the record?
Seth Flores,
And can you spell your last name?
Flores.
Okay, thank you. And were you present in this building on November 30th, 2023?
Yes, I believe so.
Why did you come to the building on that day?
I had a court date for an arraignment,
Okay, do you remember what time you showed up at the court?
I think around 10, maybe.
And when you came into the building, what happened?
Walked in, Beth approached me. Seemed like she wanted to help me. She told me I didn't need a lawyer. And the judge suggested that I should talk to one.
Okay, can I stop you for a minute? You said Beth approached you. Do you see Beth in the courtroom today?
Yeah.
What's she wearing?
Jacket.
I've asked the court to, for the record to reflect that Mr. Flores is identified as Bridgman.
And the district court is clerking it, and they're telling me they're having a hard time hearing the witness, Mr. Flores. Can you speak up and use your outside voice?
Yeah.
Should I repeat the question?
No, go ahead.
Okay. And so before you walked into the building on the 30th, did you know Beth?
No.
You just met her on that day?
Yeah.
And when you went into the courtroom, did anyone go with you?
No.
You don't remember anyone being in the courtroom with you?
They didn't walk in with me, or
I guess I can clarify. Once you were in the building and then you went into the room where the judge is, did anyone go
Okay,
with you
leading
into
the
that building?
witness, come on.
But that's just laying overrules. Go ahead.
yes, I walked in the courtroom.
I thought you would have prepped them better than this page.
Ms.
And-
Bridgman, that is not a proper objection. That's an interjection. That's disorderly. Don't do that. I know you're an adult human being, so you're capable of controlling yourself. So please do so. This is a format that has to be dignified and follow proper procedures and be orderly.
Look, you just made my case, Judge, because your oath is not properly in order.
Mr. Flores, so just to repeat, when you went into the room with the judge, did anyone go with you?
Just Beth.
Okay. And at some point when you were in the room, do you remember if Beth said anything to the judge?
That I didn't need a lawyer.
I didn't say that in the court.
Hang on, you
Leading the
can't.
witness.
Miss
You're
Bridgman,
putting
you
words in
can't-
his mouth.
You'll have an opportunity to ask questions. You can't interject during.
Well, I have to object.
And then at some point, did the judge tell you to do anything?
Speak to a lawyer.
Okay. Did you ever speak to a lawyer
Objection.
on that day?
What's your objection?
She's just leading. She's taking them through every step, which I can review. And she's telling them, you should have done this prior, Paige. You should have had them in here earlier and prepped them.
She asked him a question, did this happen? And he said, yes, that's perfectly
That's
proper.
leading.
That is
No,
not
she
leading.
should ask them
Objection.
what happened.
Do you recall what happened when you tried to, or when an attorney approached you in the hallway?
Beth tried speaking to him and wouldn't let him speak to me.
Do you remember who that lawyer was?
Gilbert.
And were you ever able to talk to Gilbert about your arraignment?
Only after,
What do you mean by only after?
I don't think I did. Maybe like a couple of days or a week after.
Okay, but not on the 30th. Did you ever talk to Mr. Gilbert?
Not on that day, no.
And did, you ever give any paperwork back to the court that morning?
Yes, I did.
Did you write anything on that paper?
Can we ask him what he did? Objection?
She is overruled.
No, she's not.
Not completely sure what I wrote on the ticket. Something about it's my personal vehicle, or it wasn't my personal vehicle, and I wasn't driving.
Why did you write that on your ticket?
That suggested detail.
And does that mean anything to you, what you wrote on the paper?
Not necessarily.
So you said that that suggested that you write that on your ticket?
Yes.
And what did you do with the ticket after you wrote on it?
I think I turned it into the civil court desk.
But you don't have it, as a transcriber, you have to keep all the notes yourself, or is that?
This testimony may be one of the most damaging moments in the hearing so far. Seth Flores' statements are now directly tying Bridgman to advising him during his court process, including suggestions about what to write on official paperwork and how to respond to authorities. Prosecutors appear focused on establishing a pattern of interference and unauthorized legal guidance, while Bridgman continues framing her actions as an attempt to defend constitutional rights and protect Flores from what she believes was government overreach. But inside a courtroom, perception matters enormously. And with every interruption, argument, and accusation aimed at the judge or the system itself, the atmosphere becomes more unpredictable. You can almost feel the patience inside the courtroom wearing thinner by the minute, as the judge repeatedly attempts to keep testimony focused while the hearing threatens to drift into complete disorder.
So
Ms.
after,
Bridgman, that's not proper objection. Stop misbehaving. You know how to behave. Behave.
I'm not sure I'm the only one in bad behavior, Your Honor, according to Article 2, or Article 3, Section 2 court.
Go ahead, Ms.
You might be in bad behavior.
Your Honor, may I approach the witness?
Once you hand it to bailiff.
Is that a copy of the court ticket? And is that your handwriting on it?
Yes.
Is that what you turned into the court?
I believe so.
Your Honor, I guess I would ask the court to take judicial notice of the ticket. I believe it's in the court's file already, what Mr. Flores turned into the district window on November 30th.
It is or not, but I'll still take judicial notice of the court's own records. Do you have it marked as an exhibit?
I do.
Is it, what number is it?
It's Exhibit 2.
2 will be admitted.
Thank you. And then after you gave your ticket to the window, what did you do next?
I was advised to leave.
Who advised you to leave?
So,
So, at that point, did you leave?
yeah.
At any point in that morning, did you address the court on your ticket?
No, I did not.
And after you initially were told to meet with an attorney, did you ever go back into the courtroom?
I think about a week later.
Okay, but that day, did you ever go back?
No.
And following leaving the courtroom, what did you do after that?
Just went out and got some lunch.
Okay, who did you do that with? Do you remember where that was?
I'm not really sure. Libby's maybe.
Okay, and then did
Sorry, Mr. Flores, you're really gonna have to use your outside voice.
and while you were at lunch, did Ms. Bridgman ever give you any money?
No. Oh, for my phone, yes.
So did she give you any money?
Yeah,
How much money did she give you?
$60.
And what was that? $60 in cash?
Yes,
And that occurred after the same day as the court arraignment in the morning?
I believe so.
All right, Ms. Bridgman, do you have any questions for Mr. Flores?
Sure.
Go ahead.
It is the use. I'm sorry it's under these circumstances. The way I recall it, you were talking to some of my friends before we talked. Or we were talking and then we went on as a whole, but.
Your Honor, I guess I'd object. That's not a question.
Sure, you'll have a chance to offer testimony under oath if you want, but you just made a statement about your recollection.
Okay.
You can ask questions this witness.
Okay, Seth. Let's see, did I injure you in any way that day?
No,
Did I cause you to lose money in any way that day?
no,
Did you tell me about what Deputy Dukowski had been saying to you under 2 other MIPs?
yeah, yes,
Did I suggest or had, offer some information to you that you had willingly, as a passenger in a vehicle, surrendered all of your God-given rights, and you did not need to do that?
yeah,
And that you have the right to stand up under common law and not be placed through tyrannical police measures.
yes.
Did you tell me what Officer Dukowski said when he pulled you over? What was the reason he pulled you over that night?
He did not state a reason.
Was it something about a Butler Road in what I could recall?
I believe he told us, or the driver, my friend, that he crossed the center line.
I believe you had told me the white line,
Yeah,
which is not the center line. And there are no white lines out there on Butler when you turn off. How far did Deputy Dukowski follow you that night?
Your Honor, I guess I'd object to the relevance of the question.
I'll overrule it. Go ahead and answer the question.
from Subway to Butler Road. They said that we crossed the line by Subway, but I don't recall.
Okay. I recall you, and listen, I know this was a high stress environment for you, okay?
By the end of this explosive courtroom hearing, the central conflict had become crystal clear. Prosecutors argued that Bate Bridgman unlawfully interfered with court proceedings and provided unauthorized legal guidance to Seth Flores during his arraignment process. Throughout the hearing, Bridgman refused to acknowledge the court's authority, repeatedly challenged the legitimacy of the judge's oath, and insisted that her actions were rooted in defending constitutional and common law rights. The judge, meanwhile, consistently attempted to maintain courtroom order while allowing testimony and evidence to proceed under established legal procedure. What made this hearing so unforgettable was the constant clash between institutional authority and outright defiance inside the courtroom itself. Every exchange carried tension, every interruption raised the stakes, and every ruling pushed the hearing closer to confrontation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't F.